Hello, everybody. Hello, hello. Just getting everybody logged on. Somebody asked me to send them a link today, and for the life of me, I don't remember who it is. And right about now, I really need to know. So give me a second and let me look and see who's in here. That might trigger a memory for me. You never know in my little blonde brain. Hello, guys. I see my peeps are here. Yeah, get the dog out of here. She's making obnoxious noises. Admit, admit. All right, everybody. How's everybody doing? Yay! Happy Wednesday. Um, we got things we need to talk about. Okay. I know last week we talked about getting bed bug certification. If you have a vacant unit, it's very important that we're doing that. I see people are getting kicked out. I'm letting them back in. I know some questions are going to come about because of what's going on in LA. And the fires and so forth. Remember one thing, what we're seeing and what we're hearing are two totally different things, okay? We're not seeing a huge financial burden on people for the most part because of the fire. And for the most part, us as landlords are doing a good job pulling together. We only have a few that are trying to find out if they look good in orange. We don't like orange, remember? So I want to hear what you guys have to say and what you guys got going on, because I know you guys have questions about things. And then we'll talk about whatever you need to. So does anybody have anything they want to talk about and get out in the open? You can either type in the chat, you can unmute yourself, ask away. I need a sip of my caffeine. This is not an advertisement.
Adi, do you know if 6-month eviction moratorium has passed or not?
I don't believe so. I think they finally heard the issue from what I hear at like 4 something yesterday.
Yeah.
They put it at the ass end of the agenda. I hear people, yes, yes. They voted for it 4-0. So are we now stuck with a no eviction moratorium for 6 months? Yeah, we are. Okay. Thank you. I have somebody that will do a little bit of research and look more into it. Look at it this way, you guys. I've been saying the entire time that the bureaucracy and the bullshit is, I'm choosing my words carefully, eye-opening. It's a little hard to swallow. I mean, I don't understand why they're pushing this down our throats. It doesn't make any sense whatsoever. They keep saying, oh, all the price gouging, all the price gouging. Really? Show me where the people have been put in jail. Where were the cops called for price gouging during a state of emergency? Okay, where everybody's talking about, oh, they're price gouging, oh, the prices are up so high. That's normal inflation. For the most part, California landlords are not violating the price gouging during a state of emergency, which is California Penal Code 396B. Hold on, Chris is giving me an update. Hang on, folks, because he went there, I'm pretty sure. They voted for it 4-0. Yes, we have it for 6 months. Half of the callers were in favor were UCLA grad students, and it was all narrative and zero data. Yep, sounds familiar. Making their assumptions off bureaucracy and bullshit, off the majority to protect the people, but the people that need protecting weren't affected by the fire. The people that were affected by the fire, for the most part, have the financial means to help themselves. And that sounded really bad. Let me rephrase. For the most part, the people affected by the fires are not in financial straits. That sounds much, they have careers, not just jobs. They probably own their house, or some of them were tenants, not all of them, especially in the Pasadena area. We see more tenants out in that area. But for the most part, they're insured. They have careers. They're financially stable. That's why we're not seeing people in the lines for food and clothing and water, is because the people that were affected have the financial means to go stay in a hotel without contacting their insurance company. I mean, I think some of the professional actors affected by the fire were fighting for hotel rooms at the tune of over $20,000 a night. Right? What I'm saying is, what everybody presumes this to be and what it actually is are two totally different things, okay? We do have members here in Widget's Way, right here on here today, that have actually helped displaced fire victims, that have went to the YMCA and held out food, that have offered their rental homes to help displaced fire victims, that have pulled furniture out of their own storage units to help furnish these units for some of these fire victims. So we as a whole, okay, are doing a great job. And I just want to say thank you, you guys, for being you and doing the right thing, okay? Sometimes we don't make a whole lot of money when we do the right thing, but it sure makes us feel good at the end of the day. And I know there's somebody in here that had a whole lot of anxiety because they were helping a fire victim and they were doing it not the normal way. Okay? Not the normal way. And yes, I'm talking to you. You know who you are. And you did something not the normal way, and it caused you quite a bit of anxiety because you were taking a risk. I'm glad it all worked out for you. I'm glad everything fell into play. And it's kind of like buying a house, right? It causes this to go on until everything's signed, sealed, and delivered. So, yes, sometimes when we're in the equation and we're adding our own skin into the game, it can become quite stressful, for lack of a better word. Holly Mitchell presented an amendment that would have tightened up the requirements a tiny bit. It failed, and then she went and voted for the original thing. Oh, lovely, 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 lovely. So we'll see. We have a no eviction moratorium. I wanted to say that it's only for fire victims, but they're just going to come up with a way to say that they were affected by the fire. Affected is a big term, and it could be easily argued. So please err on the side of caution. And at the end of the day, do the right thing. Okay? You'll sleep better. Your attorney will sleep better. And I'll sleep better too. I promise. All right. What kind of questions do we got? Because I know they're going out there. I know Val has a little mess going on with one of her tenants. So she might be chit-chatting about that. What else do we have going on out there today? Any questions for me?
I do. My name is Lisa. How are you?
Hi. What can I do for you?
Well, I have a wonderful tenant. And Friday at 1:00 in the morning, another tenant sent me a video of water leaking down from her ceiling because the upstairs apartment, the toilet tank broke in 3 pieces. I don't know how that would happen.
I do.
I had no complaints from the tenant upstairs about their toilet leaking or anything.
Of course you do. Chris, don't tell everything, you know. So you guys want to know a secret?
Yes.
Sometimes when somebody has missed the mark with alcohol consumption, and I'm making a lot of assumptions right now, but just play along, okay? And how do I know? Been there, done that, got the t-shirt, wasn't me, but been there, Okay. I want you to think about something. How does the back of a toilet tank crack? Because it didn't shatter, it cracked, right? And you said in 3 places. So I'm going to
Well,
guess that it got a
it's
flat mark this way and then a half moon. Am I right?
no, there's 3 pieces from the bottom of the tank that fell out.
Do you know why the bottom of the tank fell out? I do.
Why?
Because when someone consumed a little too much alcohol and missed the mark,
Mm-hmm.
sometimes we lose control over our body functions. And
Oh,
I just want to give an example, and I'm going to do a good one right now. Once they
oh,
sit, then they fall backwards. And that's what cracks the back of the tank.
okay.
Makes total sense now that I say that, yes?
Yes.
I had a tenant that did that once. And do you want to know what they did to try to fix it?
What?
They shoved their, I'm going to try not to laugh too hard, okay? They shoved their kids' Hot Wheels track into the tank where it was broken to try to divert the water into the bathtub. So again, water running down out the front door, down the staircase, same concept, different set of facts. That angle stop next to the toilet, you want to teach them how to turn the water supply line on and off there.
Well,
Okay?
luckily she did do that by
Well,
herself. So
good.
luckily, yes. But it's
So,
flooded water downstairs, and so now I have to fix the downstairs.
okay.
Uh,
And is the upstairs tenant your tenant also, or is this in a
yes,
condo? Okay,
yes,
so they're both your tenants. Do you
yeah,
require the tenants to have insurance?
yes,
Are you listed as additional insured or interested party on the policy?
yes. I should be.
I would contact the insurance carrier and tell them that you'd like to file a claim that the tenant in possession is liable for the damages caused because they broke the toilet tank and it flooded the downstairs unit. It's a liability claim. Got it?
Okay.
And if you were real smart, and this
Mm-hmm.
is me trying to talk to you without pointing you in the right direction the wrong way. Does that make sense?
Yes.
If it were me, let me say it that way.
Mm-hmm.
I would probably contact the restoration company that I was going to hire to do the work and have them help me file the insurance claim so I didn't say the wrong thing to the insurance provider.
Oh, okay.
Remember,
Um,
it's a claims adjuster's job to deny the claim. They
okay.
get
Well, I
somebody like me that goes through there and goes, wait, what'd you do? You did that? Oh, we're going to deny your claim. They get somebody like me that pays attention to all those little details that you fire off with your mouth, and that's what gets you in trouble and your claim denied. So, in my professional opinion, I don't even talk to insurance companies other than, yes, the tenant called me on this day and told me this happened. I immediately called this restoration company, and here's their number. You can talk to them.
oh
I
well,
know nothing.
I
I know
already had,
nothing. It's just so much easier that way.
I already had somebody fix it.
Okay, you already had
But
somebody fix it?
it wasn't a restoration company.
Okay, is it a licensed contractor?
No, he's not.
How much is the damage?
I'm still waiting for his bill, but I just wanted to know if I could even ask her to pay for the toilet that had to be replaced. It's $500. I got the plumber's bill right now. I'm waiting on the guy's bill for fixing it.
Okay, so you're understanding what I'm saying, and this could potentially still be a liability claim on the tenant's insurance, depending
Oh,
on the expense.
okay. Because the toilet's $530 just by itself.
Correct. And
With
an
the-
unlicensed contractor can do work, if I'm not mistaken, up to $1,000. It was 500.
Okay.
And Arlene's going to yell at me if I'm telling the wrong number. I don't remember if it went up to $750 or $1,000, but I'm pretty sure it went to 1,000.
1,000.
Thank you. See, I got a
Okay.
whole team of, I love all of you guys because everybody helps go, no, that's what the number is. No, this is right. You guys are all
I
awesome.
guys
Thank you.
too.
Mwah. It takes an army, you guys. Thank you.
Thank you, guys, too.
No problem. No problem. So up to $1,000, and then
Okay.
buying the toilet is a separate expense if you purchase the toilet. So the handyman wouldn't be paying for that. That would be an
Oh,
expense.
no,
that-
this is from the actual plumber, too, because the plumber
Oh,
came,
a plumber is a licensed contractor.
right, but the person that did the fixing of the bathroom was not licensed.
Okay, as long as that comes in as under $1,000, you should be fine all the way around as far as an insurance claim goes. The
Okay.
licensed plumber could be an additional expense because they're licensed, and it's just the way my brain works. You guys remember, I'm not trying to just protect her here with what's going on, but also the other things that can come at you in the scenario. So lots of moving pieces in everything we do, and remember, each scenario has its own different dichotomy, just like a tenant. Go ahead.
And so when I tell the tenant, because she just said thank you for changing her toilet, and I had told her in the morning that it damaged downstairs, but she's like oblivious to everything. She doesn't care. So what
Yeah,
do
it's
I?
not her unit.
Well, huh?
It's not her unit.
Right, right. But what do I say to her?
After the assessment and repair of the damages that were caused due to you breaking your toilet tank,
Mhm.
the following expenses have been incurred. You owe $550 for a new toilet, $1,000 for the handyman, $2,400. Would you like to file an insurance claim, or would you like to make payments on the amount that's owed?
Okay. Thank you. And so
Nope.
I don't have to get a lawyer involved with it, right?
Not at this point. I wouldn't. Can I ask
Okay.
you a couple of other questions?
Yes, she's my most troubled patient.
They
I mean,
always are. They always are. What city is this in?
we're in Downey. Downey?
I got you. My
Oh,
brain,
oh,
I have a photographic memory.
oh,
So
I'm
right
sorry.
now it's going through my Rolodex going, is Downey an incorporated LA County or unincorporated county? Is it under
It's
DCBA or
it's it's
LAHD?
it's it's incorporated.
So you're only governed by the TPA, which is California Tenant Protection Act, California statewide rent control.
Yes.
Okay. But see, that was my brain going Downey,
Yeah.
Downey. That's what was, because it's in an alphabetical list. So
Mm,
forgive me, but it's just
no,
the weird
no.
way it works.
I was just thinking maybe the microphone wasn't working. Sorry.
No, no, no. That's
Okay.
me just repeating to myself until I find the right letter in the Rolodex. That's
Okay.
right here. Don't ask. It's really weird.
Mm.
People in here can tell you, yeah, she's psycho.
So with this tenant, she one time she claimed that she had mold, and so we brought.
Hang on. Julia says, in regard to the toilet and leases issue, do you say up front that they're financially responsible before the work's done, or when the bill comes at the end? It doesn't matter when you tell them that they're financially responsible. And Bilsey, I'll answer your question too, because this is going to answer everybody's questions all at once. So it doesn't matter when you tell them that they're financially responsible. At the end of the day, they're still financially responsible. Look at it this way, okay? What if the tenant moved out and that's when you found that the toilet tank was broken and this damage was done? They would be responsible with it with their security deposit disposition. So it doesn't matter when it happens during the tenancy, it's still the responsibility for the tenant regarding the damage, okay? So that's where the key is damage. And they can deny the responsibility until they're blue in the face, but I'm sorry, toilet tanks just don't explode for no damn reason, okay? I'm just saying. Just saying, okay?
Yeah.
So lots of moving pieces there, but there's a lot of things that you can do. You need to use photo documentation
Yes, I have
regardless.
that. Yeah, I have that.
So of the damage that was done, the repair afterward, that way if you decide to deduct it from their security deposit 5 years from now when they vacate, you can.
Mhm.
But yeah, it makes it a little less. Is this a single family or a multifamily dwelling?
It's a multifamily. It has 16 units.
16 units.
Mhm.
So you have to have an on-site there too.
I do.
Yeah. Yeah.
I know.
Yeah. And now you have to also offer them to pay the $10 a month for the credit reporting.
Yeah, in April, yeah.
Yep.
Okay,
Get ready because that's coming.
she's not going to want to do that because she's always late.
You guys, remember what's not reported is going to tell us a story too.
The late, they don't report the late. Yeah.
All
On the
right, let's
credit
get to. I got you. Let me get to some of these other questions. We got a few of them. Okay.
Thank you. I appreciate you.
No worries, no worries. And I'm here if we have more questions. And people are saying they were hungover. Everybody's telling us why the toilet was breaking.
Well, somebody asked me if they were having sex on it.
And I've seen people stuff Hot Wheels tracks in there and try to divert the water into the bathtub. I'm telling you, I could write a book. Lake Elsinore, Belsey, this is you. 7-unit complex. One of the tenants reported a broken window in the back of the property. According to the maintenance person, there was nothing that could have broken the window. The neighbors report hearing big, ugly fights in that unit. We determined that the tenant broke the window. However, we fixed it but charged the tenants for it. These tenants are threatening to take us to the housing authority and getting me deported because of my accent, I guess. Well, good luck with that, Belsey, right? The lease states that the tenant is responsible for damage caused by the tenants. Now the tenants claim that the window is broken due to normal wear and tear. Have you ever heard about a broken window due to normal wear and tear? Belsey, I'm going to answer your questions all in one shot. The tenant is threatening to go to the housing authority. The housing authority is Section 8. I don't care if they go to the housing authority. I don't care if they tell Section 8. If you have a professional window replacer that says that that window was broken from the inside out, then that would fall on the tenant. That means it was broken from inside the unit out. They can usually tell which way the window broke by which way the glass falls. If somebody throws a baseball in the window from outside in, all the glass goes into the property. If it's broken from the inside out, all the glass goes out of the property. Does this make sense to you guys? That's how they can determine who, when, where, what. At the end of the day, remember one thing. The tenant is responsible for damage. So if they don't want to pay the expense, you could, depending on what city it's in, deduct it from their security deposit. You could put it on their ledger and deduct incoming payments, but I wouldn't do that in LA, okay? For rent coming in and deduct it for past due expenses. So Belsey, let them go to Section 8. That's who the housing authority is. I don't care if they tell Section 8 that they broke a window. The reality is this is going to be duked out in the security deposit disposition when they vacate, or you could sue them in small claims while they're still in possession, but I don't recommend it because replacing a window is not worthy of poking them in the eye. Next question, Roadrunner. Hey, Patty, we have a tenant in Joshua Tree in an apartment triplex. Got you? The tenant's parents came into the office and let us know that she is on meth currently and not working, that she has homeless people coming to her house to stay with her. She has broken the sliding glass door as well. We're trying to offer her cash for keys to get her out, but I want to know what the other possibilities are. Give me a minute. It would be horrible if someone called the WeTip hotline and reported the drug abuse and the homelessness going on at the property. It would be horrible if one of the other tenants notified law enforcement about the additional activity and asked for extra patrols in the area. Nobody say anything, please, because I got to be careful what I say right now. It's a matter of time before she ends up in jail. Is she paying her rent? The second she's behind in the rent, serve a 3-day. Serve a cure or quit on the broken slider for damages. and go that route. You're in Joshua Tree, so this is going to be heard out there, and your court system out there for the most part is pro owner. So I'd base it on the damages to the property. Do it on the 3-day curable breach of covenant for the broken slider. If she don't fix it in 3 days, you know what to do. Then start the quit and go the process on evicting them for a material breach of the lease due to blatant damages to the property. That's what I would do. Based on the area that you're calling me about or asking me about, you guys, why I'm saying this is I am not telling you to do this in the city of Los Angeles. Okay? I'm not telling you to do this in the county of Los Angeles. She is way out there, okay? In Riverside, San Bernardino County. She's out there in Joshua Tree. So different set of facts, whole different court system. She's a one and done on a cure or quit for a material breach for the most part. That's the route I would go. It would also be horrible if someone called code enforcement. Why cause tenant harassment ordinances? Well, I know, but it sucks because we can't call or it is harassment. It's bullshit. We can't use police powers to our advantage. It sucks. Val, what if she denies tenant? Oh, we're talking about the toilet for our other gal. Okay, here's Roadrunner back. Tenants in the other complex are nervous of the homelessness coming around. It's not just homelessness. Let's face it. If she's doing meth and she's on methamphetamines, it's not just homelessness. We're now talking about drugs, and it's probably not just meth. It's probably fentanyl. There's probably sexual trafficking going on. I don't mean to be an ass, but if you're on drugs and you don't have money, how do you get your dope? Just saying. It doesn't take a genius to figure out what ends up happening there. So with all of that going on, we want police power because we don't want to encourage that in our neighborhoods. And it sucks that they hold that against us for using that police power. It's garbage. Hi, Patty. We have a tenant in the city of LA. Holly, this is you. Who we filed a 3-day notice to pay rent or quit on January the 14th. I filed it with the city within the 3-day requirement. We've hired an eviction attorney and they have tried to serve our tenant an eviction notice, but the tenant evaded the process server. We're now waiting on a judge to sign in that eviction notice to be posted. It's called a posting order. And yes, this is just another way that they stall things out, okay? Oh, hang on. Somebody's trying to call me. Don't call me on Wednesdays, people. Come on. It's you guys. It's not you guys. It's somebody that knows this is what I do on Wednesdays and totally forgot. I guarantee you. Hang on. Let me go back. I lost it, Holly. Let me go back. We hired an eviction attorney, and I'm going to skip all that, but I'll go to it so everybody knows. We've hired an eviction attorney and they've tried to serve our tenant an eviction notice. It's not the notice. They've tried to serve him with the lawsuit, but the tenant evaded the process server. So now we're waiting on the judge to sign. It's called a posting order, but it's so it can be posted on the tenant's door. We've not spoken to the tenant since the posting of the 3-day notice to pay rent or quit. Good. The tenant has not paid rent in 3 months and counting. Good. Should we send a reminder that the rent is due on March 1st? No. Also, this tenant's renter's insurance expires on March 20th. Do I contact the tenant to keep their renter's insurance in effect? No. Let me explain, okay, Holly?
Okay.
And work with me, okay?
Yep.
Once we have a notice in play, if we use our mouth and offer something else or talk about something else or serve a different notice, this notice is now in play and this notice is now trash. So your 3-day pay rent or quit served on January the 14th would become trash if you were served a reminder on March 1st.
Okay.
So leave your 3-day in play. Everything is in order. You're in the middle of an eviction. So here's what I could tell you, okay?
Okay.
Do not pass go. Do not collect $200. Do not sneeze without contacting your legal counsel first, because at this point, Everything you do can and will be used against you,
Copy that.
even if your intentions are just purely genuine, like sending them a reminder voids your 3-day notice.
Okay.
And you wouldn't even have known that. And your attorney wouldn't have known that. And what would have happened is when you got into the jury trial and the argument started, they would say you waived the notice.
Right.
And then your attorney would go, "You did what? Okay, we have to start over." Okay,
Right.
so you
Okay.
just don't even go down that road. Anytime you're involved in legal, here's my advice to you guys. And I'm going to give advice, okay? If you are going to hire an attorney to stand next to you and represent you in court, that's who you want, telling you what to do, what notice to serve, how to serve it, when to serve it, why to serve it, who else to give a copy to. You want to do exactly what that attorney is telling you, not what I tell you, not what she tells you, not what he tells you, not what they tell you, what that attorney tells you. Not that attorney, this one, the one that's standing next to you when you're going in court to battle. You know why? Because it's that attorney that's standing next to you that's ready to argue the points that are in their head to win your case. So when you deviate from whatever that attorney's thinking, you mess up their game plan. You mess up their playbook. So it's very, very important once you commit to starting the legal process that you follow the leader, and your leader is that attorney that's standing next to you in court.
Okay.
I can give you process and procedure. I can explain the why behind things. I can help you as much as I can, but you want to take direction from them. That way they know exactly what's going on and they're ready to help you combat those weird things that happen. Okay? And
Got
that
it.
goes for everybody. Everybody.
Yeah,
All right.
that's what I thought. And I have not communicated with our professional renter. But I'm just living in panic based on what was voted by LA County last night that this is all for naught. I'm just hoping we can still have a trial at some point. We can still go to court, and this BS about, my tenant didn't lose income over the fires. This has been going on forever. I mean, what do you think? Am I going to get hosed because of this LA County thing?
I can't answer your question.
Yeah.
My crystal ball is broken.
Yeah.
I mean, I'd love to tell you how I think it should go, but the reality is, how much money do we have to spend to prove that we're right?
Right. But I also can't keep subsidizing somebody.
No, you can't. And at some point, they have to bend and help us. So are they not going to foreclose on us owners that can't evict? Because that's going to be the next thing that comes about.
Right. Yeah.
Just buckle up, baby. It's coming. Okay.
Yeah. Well, and I will say, if anybody I watched the meeting last night, which was supposed to happen in the morning and ended up being at 6:30 at night because we have just all day to watch these meetings, right? And Catherine Barger abstained from voting, and she did ask the legal counsel, at what point is the county liable to landlords when tenants can't pay? I thought that was an interesting question on her behalf. I don't know if anybody else caught that, but that made me go,
I think everything they say makes us go, All right, let's get to Val's question. I had a broken window incident. The tenant claimed no responsibility, but cleaned it up before our guy came to fix it. We know he did it. It was a weird sectional window. So my guy replaced the section with a piece of plexiglass that I already had. The tenant is now complaining that he doesn't like it. I don't care and plan to raise their rent soon, but I cannot prove he did it. I just know he did it. He's always full of excuses. My question becomes, if the window is a stationary window and it doesn't open and close, and you replace it with a solid piece of plexiglass, then that's your right as a landlord. If it's an opening window that opens and closes and you replace it so that it's solid and it's stationary, it could be a problem for you. Okay, that's all I'm saying. Ruiz, I have a single family dwelling home with 3 roommates. I want to end their tenancy, but one roommate does not want to move out. can you explain between lodger versus tenant? A lodger is somebody in a hotel that or a campground that has not lived there for more than 14 consecutive days is what you see on hotels, but the rule is 21 days or
I think it's
28
30.
days.
I think it's 30, Patty.
I think it's 28, but regardless, that's the difference. Once they stay there longer, and we'll go with 30 just to appease Arlene, just for the sake of a number. And once they are there for more than 30 days, they're no longer lodger. And I use the word innkeeper because that's how it's written in law, is innkeeper law, which is what a lodger uses. So think about an Airbnb, think about a hotel. They don't pay their hotel fee for the night. What does the innkeeper do? They call the cops come and kick them out. Unless they've stayed there for more than 30 days, then it becomes a tenancy. Okay? Then it creates a landlord-tenant relationship. Regardless of whatever agreement's in place, it could be an oral agreement, it could be a written agreement, it could be a check-in card at a hotel. Does it sound, are you playing along? Could be anything, okay? If they don't want to move out, can you explain the difference between lodger versus tenant? Is there a difference in the eviction process? Hold on. Yes, the difference is if they're there less than and it falls under innkeeper law, you call the cops. If it's more than, it's landlord-tenant law and you do an eviction. I want to gain full possession of my home for use of a family member and major remodeling to my 120-year-old home. Then if that's exactly what you want to do and you're determined to do it and you're prepared to pay the relocation fees that are required, then I would go knocking and talking to the tenant. And why I say that is I'm just going to throw out some numbers, okay? So don't panic on me. I'm going to say, for the sake of a number, that relocation fees are $25,000. I would suggest that you go talk to the tenant and offer them $30,000 to be out of the property in the 60 days. Why am I telling you to offer them more than what the city requires? Ching, because if you offer them more money at hello, they're less likely to fight you through the process. And evictions cost a lot of money. Between $60,000 and $80,000 is the average price that a landlord is paying for an eviction. And that is taking about 8 to 10 months to get there. So when you add the time, the money, the legal expenses, and the relocation fees, it comes out to 60 to 80 grand. If you're ready for that, and you're prepared to go forward and pay all this stuff and have it ready to go, I would honestly contact attorney Sasha Struthers. She does cash for keys contracts. Before you do anything, let her try to go make a deal with the tenant to pay him to go away. And if that doesn't work out, then I would start the eviction process, pull the permits or whatever it is you need to do for your JCO ordinance so you can get in there.
Do you have that number? I'm sorry, do you have that number for Sasha?
Yeah, if you bear with me. Or Arlene, are you in a place where you can look that up for me real quick?
Yeah.
Thank you.
Yeah, okay,
I'll put
Arlene
it
will
in the
look it up
chat.
for
I'll
me.
put it in the chat.
Perfect. Arlene will put it in the chat for us. Thank you. You guys are a great team. I love each and every one of you. And I had to tell my web guy at the end of last meeting, can you edit out the last portion of our meeting about keeping face and all of that? Because I don't necessarily want to share that story with the whole world, but I did want to share it with all of you. And thank you for helping me laugh a little bit. I am keeping my skills on my toes, you guys. So we'll see what happens here in the near future. But yeah, Patty's getting her feet back wet in talking with tenants. It's quite interesting. Some of the things that they come up with is extremely creative. And I thought I had some pretty creative tenants back in the day. Let me tell you, the things that are coming out of their mouths in LA these days doesn't shock me one bit, but makes me scratch my eyebrow, let me tell you. Belsie, what you got? Property of 4 residential apartments and 3 commercials in East LA. what is the rent increase allowed? On the commercial or on the residential? And you know what I'm going to tell you? I'm going to ask you if it's governed by RSO or
Both.
DCBA. And I'm going to guess that because it's in East LA, it's governed by RSO or DCBA, and you're probably looking at 4% of an increase. But stay housed.
Exactly.
I'm sorry?
Yes, exactly, is what I said.
Okay. I would go to stayhousedla.org and look it up that way. But you're probably looking at about 4%. And then on the commercial, at this particular point in time, they don't have any rent control on commercial buildings within the county of Los Angeles that I'm aware of, or any, I'm sorry. Oh, I thought somebody goes, yes, they do. And I'm like, where? Because I don't know anything about it. The only protections that I'm aware of that are now being offered for commercial tenants is they're qualifying them based on how many employees they have, whether they're a qualified commercial tenant or an unqualified commercial tenant. And the qualification has to do with whether you can, hold on, I'm trying to see the ordinance because it just passed in January. It has to do with us charging for notices served to a tenant. We can't charge commercial tenants anymore. And there's something else we can't do to a qualified commercial tenant. And before this meeting's over, it will fly up in my brain and come to the front of the Rolodex, I promise. What type of receipt is legally required or for best practices for a security deposit? The California Apartment Association doesn't seem to have a separate form, but seems to mention in the lease. How to be clear about it when I already have a holding deposit that's less than a full month's rent. Okay. When we're in the transition period of we approved you versus it's time to move in, we have this blank space in between from, and I'm just going to throw numbers out for the sake of numbers. April 1st, we approved them, and they want to move in on April 30th, okay? So between the 1st of April when we approved them and the 30th of April when they're going to move in, what do we have protecting us right here? What is going on between these two dates to help protect us as a landlord? That's what Chris is talking about. He's talking about a holding deposit agreement. So what we do is we take a holding deposit agreement. CAA has one on file, and it is a separate agreement. Separate agreement that says that we can hold this amount of money that will then get applied to their future lease. It's how we can charge per diem, which is daily rent, for lack of a better way to explain it, for each day we held that property off the market for the tenant. It also gives us, the landlord, a door to get out of the relationship in the event we need to back out. What penalties do we have? We have to return the deposit and not charge them that daily per diem. Oh, okay. So that's how we use a holding deposit to help us between the transition period of approval and signing a lease. We do not pre-sign leases, okay? We do not pre-sign leases. Do you know why? Because if you have a holdover tenant or a flood, or somebody breaks in and destroys the property, or then there's a squatter, or life happens, or a murder, death, suicide, whatever. You have a unit and you have a tenant that's vacating and a tenant that's going to be moving in, okay? This tenant doesn't vacate when they're supposed to, so this tenant can't move in. What do you have to do as a landlord? If this person signed a lease, you have to put this person in a hotel until this person gets out at your expense. Reasonable accommodations. We don't want to do that. We don't want to have to pay for that. A holding deposit is what protects us as a landlord in the transition between application approval and lease signing. Okay? It's what protects us. It's what allows us to make money in the event they go away, back out, change their mind, or allows us to give them their money and not move them in because they don't have a signed contract in the event that there's a fire, a flood, a murder, death, suicide, whatever. Okay?
Patty,
So holding...
Is a holding deposit typically 1 month's rent?
A holding deposit is the amount that you're collecting to hold the property for the tenant. I usually call it the security deposit, whatever I'm charging in the transaction, and that's what I want them to give me. And then I want the first month's rent on the day they're signing the lease and moving in. So for me, for the most part, that's what I want. Yes.
Okay, thank you.
No problem. Val, letting the group know what you told me. My future rent increase in Kern County came out to $999.80. I asked Patty if I could charge $1,000, and Patty said I would not look good in orange. Okay, you know, and LA County, put on your earmuffs, okay? Right now, we're in a state of emergency until March 8th because of the fires. Once the state of emergency is lifted, we still have protections in place for an additional 30 days. So till April 8th, unless they get together, change their mind and extend stuff, okay? Until April 8th, there's a state of emergency because of the LA fires. After that state of emergency is lifted, people may do more rent increases. Some of us have a single family home. Some of us have tenants that aren't affected by the state of emergency, okay? Technically, we could potentially do a rent increase of over 10%. The problem is there is such a thing called a constructive eviction. And how it's explained to me, and as simple as I could explain it, is if you're changing the rules so badly that they're not going to be able to live there, or you're raising the rent so quickly, so fast, so high, like doubling it. Look at it this way. I could give you a 90-day notice if your rent's $2,000 and raise it another $2,000 to $4,000, right? If you're not in a state of emergency, exempt from state law, you guys following along? Okay, so that could cause something called a constructive eviction. So what I'm telling Val is don't raise your rent so high, so quickly that you put yourself in that position where now it's being argued in court that you look like a slumlord because you raised the rent so quickly, so high, they couldn't possibly pay it, which forced them to be evicted. You constructed an eviction to get them out. Constructive eviction, okay? Be careful with those. They suck. You guys are welcome all day long. Okay, what do you suggest I do if rent is $26.50 and I took a $1,500 holding deposit because it was 2 weeks from the lease start? How much is the security deposit? Because they may owe more when they move in for the security deposit. Remember, the holding deposit and the the holding deposit and the lease contract are two separate agreements. So if they give you a holding deposit of $1,500 on the day they're signing the lease, the security deposit amount on the lease could say that it's $26.50, and the $1,500 that they gave you in a holding deposit will be applied. Julia, hey Patty, what's the statute of limitations for going after a tenant who moved out but left a balance? This would be small claims. Julia, statute of limitations on landlord-tenant litigation goes like this. Everybody pay attention. And what she's talking about is how much time do I have to sue them after they move out? Because that's when the clock ticks, okay? If they're on an oral agreement, the statute of limitations is 2 years. If they're on a written contract, the statute of limitations is 4 years. There's one thing I want all of you to remember right now. If you have 2 years to sue them on an oral agreement and 4 years to sue them on a written agreement, it goes both ways. They have 2 years to sue you on your oral agreement or 4 years to sue you on your written agreement. Okay? So when a tenant moves out, now you know why I say keep all your documents for at least 4 years. And I always say keep them for 5. That's why. Okay? Because they can come back and sue you up to 4 years on a written contract. And you know, most of the frivolous, I gotta choose my words carefully. Hang on. The screen is not frozen. Widget is frozen. Sorry. Most of the frivolous bullshit lawsuits that I've seen come about usually get served right before the statute of limitations is going to expire. Example, if you have an oral contract with somebody and they move out and you kept the security deposit, blah, 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 you may see a lawsuit come about at month number 23 of them vacating. Okay? Why? Because at 24 months and 1 day, they can't file a lawsuit anymore on an oral agreement. Remember? 2 years. So a lot of times I see weird things. Let me give you an example, okay? I had this guy that worked for me, and this is way back when I was a regional manager. He's a licensed real estate agent. He has every legal right to perform acts as a licensed property manager because he's a licensed agent, okay? But he did our leasing. He went and showed the properties. He was really good at it. He did a move-in for me a few times in a bind. I hated asking him to do move-in inspections because he documented everything, which made it literally impossible for me to charge the tenant when the tenant moved out because he marked every scratch, every cut, every nick, every normal wear and tear, light scuff marks. Oh, he'd mark every single scuff mark in detail, put a ruler next to him, take a picture. I mean, this guy was thorough. I wanted to put my little hands around his neck and squeeze until his little head popped off. Because sometimes when I'd go back to fight for the landlord on the damages, it was really hard for me to do because it looked like it was destroyed when they moved in, but it wasn't. He was just very thorough. Not exactly always in your favor, but in this particular incident, he saved my asset. Okay? He moves the tenant in. The day the tenant moves in and signs the move-in inspection form that she walked through and agreed to, she fell down the stairs inside the single-family home and broke her leg. I ended up evicting her for non-payment of rent. At about month number 14, 15, so just after she'd been there a year, okay? Anyway, long story short, right before her 4-year statute of limitations or whatever is going to expire a few days before, we get served with a lawsuit for the slip and fall in the apartment complex because of the poorly lit common area. Huh? This is a single family home. There's no common stairwell. That's a staircase inside the house. So I pull up the move-in inspection and see who did it and start banging my head against my hand. And then I see that he marked on there that the light bulb was burned out at move-in, and she signed and agreed to it. So she had active knowledge the same day that there was no light in that stairwell. She knew. So I was mad. I was upset. I was pissed. She said the reason she couldn't pay the rent is she lost her job because she broke her leg. But I know darn well her boyfriend didn't lose his job and he made plenty of money. She didn't even need to work. So, hey, but whatever. Here's the thing. I got on the phone with the attorney because they were coming after ownership of the property management. They were coming after everybody, okay? And I tell the attorney, and this is the first time as a property manager that I realized just what attorneys did, and I wanted to learn more. It got my attention to make me go, wait, what? So I'm talking to this attorney, and this is a corporate attorney, so I'm nervous and I'm scared. And he's like, tell me about this. And I'm like, okay, first of all, in the complaint, it says it's a common area. This isn't a common area. This is a single family home. She marked on the move-in inspection that she knew the light bulb was burned out. I have a signed copy of that. So I'm sending him all this evidence I have to show him. And he calls them and tells them that they filed their case wrong because this isn't a common area, that it's an interior of a single family home. And the attorney calls me back and goes, okay, this should all go away now. And I go, what do you mean they're just going to refile? And he goes, they can't refile. The statute of limitations is expired. So I was like, huh? So then I realized how that works and why they wait till the last minute sometimes. And maybe it's so you don't have all your documentation anymore. Okay. 5 years, keep all your documents. No joke. Hope that answers that question. You have thousands in uncollected judgments. Yep. There's Sasha Struthers' information. She is an attorney in LA County. She covers all of Ventura County, all the way to San Diego. So from Ventura County to San Diego, she's a cash for keys specialist. She does not do evictions. She does not specialize in property management issues. You can call her and ask her a question. She may just refer you right back to me, believe it or not. But I do try to encourage people to use our legal system's broken. I don't need to tell you guys. You're on the receiving end of the bureaucracy and bullshit. So, you know. So if we have an opportunity to avoid that process and just do cash for keys and be done, Sasha's our girl. She knows what she's doing. She's got a great approach with tenants. She's been extremely successful in her negotiations, and she's an attorney. So you know how some municipalities say that you have to give it to the tenant in their primary language? They have up to 45 days to rescind the offer, blah, 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 blah. She knows all of that. She's an attorney. That's where she focuses. So instead of you trying to figure it out, and don't call me to figure it out because I'm going to tell you to call her. That's her ball of worms, okay? Let her tell you. But she's amazing. If she can pull it off, she does a great job. I highly suggest and recommend. And in the event you guys have to evict, unfortunately, please remember, don't whip out your credit card. Don't be quick to whip out your credit card. That's at 27% interest. Makes more sense to do a HELOC or a second on your home and leverage your asset to help you build your asset, right? Don't leverage your own bank account. It doesn't make sense financially. Julia, I will look at part 2. I also need legal advice. Do they have referrals? Can they help me with an eviction process? Yes, I got you. Just give me a second. Let me go to Julia's part 2. Let me find it. Julia, hi Patty. What's the statute of limitations? Got you. Can you give me more detail about that Fontana case where the judge didn't rule in the landlord's favor in regard to the security deposit? I'm surprised at the outcome, especially since it was Fontana. You want me to tell you about surprised at the outcome? Check this out. Tenant filed a small claims case saying that the owner didn't do the security deposit disposition within 21 days. She was right. The owner didn't do the disposition of security deposit within 21 days. She did an estimated within 21 days. And then she did the final within 14 days. Actually, she did it within 3 days of receiving the final invoice. So, per statute, per the civil code, per 1950.5, she followed the law. Okay, all the ducks were there. Everything's crossed, everything's dotted. Okay, it's all there. I'm looking at it. Okay, so go to eviction court or go to the small claims case hearing. Hearing gets held. Tenant gets to talk for about 30 minutes. Owner gets to talk for about 3. No joke. How do I know? I was there. Watched the whole thing happen. Felt very confident that we would prevail. Owner gets a letter in the mail. The tenant's been awarded $3,600 out of her security deposit. Wait, what? No, this is no, 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 no. We followed the law. So we file an appeal in Fontana court. This is where you're going to see somebody in here go, what'd you say? Filed an appeal in small claims. Hire an attorney to represent us because we don't feel that we were given due process because process of law wasn't followed. The same judge heard the appeal that heard the original case. And in the second case, we were then penalized by another $80 that was then awarded to the tenant. So instead of $3,600 and whatever, it was $3,700 we had to give. We still lost. And the reasoning that came out in the ruling was the final disposition didn't include the final invoices. Bullshit, they're right here. I'm looking at them. But I don't want to keep going back and arguing and keep poking because every time I do, it costs me more money and she gets a bigger judgment. I don't understand that. I've talked to 3 attorneys about that don't understand that. I've been told that the same judge shouldn't have heard the appeal. And see, I'm getting things coming to me, but I'm being told to go to cjp.ca.gov and file a complaint because this is bullshit. What's happening? Process of law is not being followed. It is garbage. And there is something we can do, but this all falls under my thing of how much money are we going to spend to prove that we're right? I just want you to hear that, okay? We're talking about an owner that's been to court twice now, okay? And still has to pay $3,700 to the tenant. Or do we keep fighting and keep going and pick and choose your battles, man. Pick and choose your battles. Sometimes we got to spend a lot of money to prove we're right. And that's the part of this industry that sucks. And I can't stand it. You guys know as well as I do. I just went through this. Not with fair housing, but with the Civil Rights Department. It's no joke. Okay? No joke. All right. Does anybody have anything else? I know we're over the hour. If somebody has something they want to say, they're going to say it. So I am opening the floor to anybody that wants to say anything. If anybody needs to go back to work, we'll see you next Wednesday.
Patty, I would
Go
ask
ahead.
you one more question, if I may.
Sure.
Goes back to the toilet. This is Lisa. When I give her the papers, do I give her like a 3-day cure or quit with it?
Well, what are you asking her to do?
For her to pay? Pardon me?
Well, you have options, okay?
Right.
You're in the
Right.
city of Downey, if I remember correctly.
Yes.
Okay, thank you, because I needed you to correct me if I was wrong. And see how quick that Rolodex came forward? Yeah, it was fresh in my mind. You have options, and I'm being honest with you, okay?
Mm-hmm.
You can go the route of going through her insurance company, which is the route I would probably try to go.
Right.
You could then, if you weren't able to succeed there, then you could, as long as you had photos of everything, damage,
Yes.
repairs, everything, because of the new law,
Yes.
you could hold it on the books and take it out of their deposit when they vacate. But let's face it, it's going to eat that.
Right.
And then you don't have anything for other damages, but technically it's a damage. Or you could sue them in small claims while they're
Okay.
still in their in your house and get a judgment against them. And then garnish their wages. But
Mhm.
you need to figure out how much we're talking about and what that's worth to you. Does that
Mhm.
make sense?
Yes. But okay, I have another question. If okay, this is my tenant that's like just a mess. She's like a trouble tenant. Can I use that as a breach of contract because of damage to the apartment?
I'm going to continue to talk out loud, and when I say something wrong, you correct me.
Okay.
I'm going to assume that this court case would be heard at West Covina Courthouse. Is that correct?
I'm not sure.
Yeah. It's important you know what courthouse you go to because you need to know how those judges rule in that area. Does that make sense?
Okay. How
Okay,
would
and
I
that's
would I
me
find out?
just talking to you out loud, okay?
How would
Your attorney's going to be able to answer those questions. I
I? Oh,
can't
okay.
because
Okay.
they're in those courthouses every day. I'm not. Okay.
Okay. Okay.
Hey, Patty,
Yeah.
just to piggyback on a legal thing, are there, are they, are the plaintiff's lawyers doing stuff on contingency when if they bring up claims like harassment or other expensive claims against landlords?
No, actually, they're not. Tenants' attorneys are going in pro bono. Tenants are having to usually front $100 if they'll take the case, and then they get 33 and a third percent of any monies awarded to the tenants. And let me tell you, I just found a tenant attorney that isn't charging 33 and a third percent to the tenant. They're charging 40%.
But if the lease caps legal fees, doesn't that kind of put the kibosh on them?
Well, that can put if the lease caps legal fees, that doesn't necessarily stop them from continuing to litigate because remember, that tenant advocate group gets paid 33 and a third percent to all monies awarded to the tenant. So their money they get paid for the most is in that settlement at the ass end of it, not in the litigation part of it or any of that. And a
Right,
lot
but
of
if
those work pro bono until then.
in some cases when your family has pro bono attorneys and you're not afraid to throw down litigation wise, that might kind of change the equation, no?
Yes, I think it
Because we don't
completely.
really need to settle. We can just draw it out as long as you want to spend money and you're gonna, at the end of the day, when you get awarded your fees and costs, enjoy that $500 on the lease, buddy. You're gonna earn
Well,
it.
Chris, with all due respect, you're in a position because your family has attorneys close by that you have that capability. But for all of my other members, we
Right.
don't. We can't hook them and tell them, "Come on, I'm going to take you for a ride."
I
And
would just think that
fight
capping the
it.
fees is still going to be a good idea because you're kind of dissuading anybody who's getting a percentage.
Capping your attorney's fees is a very smart thing to do. But remember, attorney's fees and settlement is two different amounts.
No, I get it. It just, yeah. Okay.
Yeah, but that's how they're getting it is they're like, okay, you're capped at $500 attorney's fees or each party's responsible for their own. So I'll take your case, Mr. Tenant, but you're going to have to pay me $100 to take your case. Why? Because they're going to lunch with that. That's cash in their pocket, right?
I'm assuming some of them, as soon as they get a strongly worded F off letter from an attorney, a licensed attorney in the state of California, are probably gonna
Try to
maybe put it
settle. They're going to
right.
try to settle. They may pay a 10,000 to settle out of court, so they're going to test the water that way and see if they can grab it that way. So there's all kinds of ways that we as landlords can help deter opposing counsel from attacking us. But remember, it's just a deterrent. It can still happen.
No, I know. There was an attorney on an AGLA webinar that was talking about there've been some things where as soon as they find out they're not just submitting the claim to insurance, as soon as they get a letter back from an attorney, that the entire threat of the lawsuit goes completely away because
Yes. I noticed the same thing when I stood up to the civil rights department with a property manager that was getting bamboozled. And I wanted to make sure that that property manager didn't get bamboozled. So it's like, how much money are we going to spend to prove that we're right? But we're going to ride this out. We're going to go through this process so we can report back to all of you if it's fair or not. Because the rules are changing. Now Fair Housing is offering settlements to settle out of court for 10 grand and an apology letter. Apologizing for what? I didn't do anything wrong.
Well,
So,
also they now imply housing is a civil right.
bingo.
They changed the name, which is I'm sorry, but I don't agree with that.
Right, exactly. So it again, very broken system, but we the people are the ones that are getting the short end of the stick.
Does anybody else want to ask something? I don't want to take time, but I trying to not use Patty's time outside of Widget's Way Wednesdays.
It's okay, but I see something else really quick. I have a triplex that rents under market to a group of most likely undocumented workers. I heard they were not working due to fear of ICE baby. They are coming up for an annual rent raise. I'm a tad worried about them squatting and needing to evict. So I need to weigh whether to raise rents or not. Val, heed my warning, okay? Do business, raise rent, okay? Just hear me out. Do your job. Don't change anything. If they're due for an annual rent increase, give them the annual rent increase. If they choose to run and or hide due to whatever their immigrational status is, we cannot discriminate against immigrational status or national origin. They are protected classes in the state of California. So, with that being said, if they choose to not go to work because they're scared of ICE, and they choose not to go to court trial because they're scared of police power, you're still in the same position. It just became a little easier. I hope you understood what I'm saying. Usually if they're afraid to go to work because they don't want to get caught and get deported, they're sure in the hell not going to show up in a courtroom where they have bailiffs and cops. I'm just saying. I know they don't do that. And you know they don't do that, but they don't know they don't do that. Got it?
All right. Does anybody else want to ask something?
Going back to Alicia's issue,
sorry.
how do you find out who your judges are? Go ask your legal counsel. Your property is in an area. Example, if you're in San Bernardino, you're going to Fontana Court. We all know it. So now you need to know how your Fontana Court judges are ruling. Are they ruling like LA and requiring you to get 7 curables before you do the quit? No, for the most part, they're one and done. Okay, that's what you need to know. That's why you need to talk to your attorney. You know, you don't want to come from an LA area where you have to prove a nuisance with 7 curables before you do the quit. And then you go to LA and you do that and the judge is like, why'd you do this? You only needed 1. This looks horrible. Well, no, it actually looks like you really tried to work with the tenant and give them the opportunity to correct the problem, and they didn't. So again, it just depends on the jurisdiction and how those judges are ruling. And the person that can answer that question the best is your attorney because they're in those courtrooms every day. Okay, Chris, what do you got?
Yeah, I'm sorry. I just want to clarify. So, because I looked at the CAA lease and it talks about like the deposit amount, the security deposit. So would you just put the full 1 month rent security deposit there and just not mention that you've already taken $1,500 on the holding agreement?
Well, the holding deposit agreement becomes null and void once the lease is signed. Is that correct?
I mean, that's my understanding. Well, I guess technically the amounts are applied to the first month's lease and the security deposit is what it says.
Absolutely. Absolutely. So
So just keep it all together. I'm just thinking like down the road, I want to have proof like, I received X amount of money in security deposit from them.
Correct. Your lease is going to act as that receipt.
Okay.
Your holding deposit is a separate contract between approval and lease signing. It covers the gap in the middle.
Right. So I can just tell them, well, I need X amount before you're going to take possession.
Bingo. I need the remainder of your deposit and your first month's rent.
Right. And then they're saying they want a lease. I'm not giving them a signed lease. Are you okay with giving them a blank lease that has all the terms, that doesn't have what do you say, don't have the address? We're kind of playing chicken as far as
hold on. How it was explained to me is once I release a lease to them, I intended to rent to them. So the intent of giving them a term for 1 year or whatever the lease is there. So it gives intent, and it can create an argument. And I don't want to go into any more detail than that, and you know why.
Well, I don't want you to engage in the unauthorized practice of law, Patty. But, so if you were me and you had people coming from abroad, and I wouldn't generally advise this, my situation is very particular.
Very unique.
It's a very, very unique situation. For most people, I would say don't get involved with people coming from abroad because there's too many risks involved.
You can't collect the debt. If they create a debt, you cannot collect over international lines. Forget state lines. You ain't going across borders, okay?
So, anyway, we have our own reasons for why we're doing this.
I know, but we're saying
I'm trying to explain
so
it.
Everybody else hears why.
I'm trying to explain it to everybody else that no, we're not complete idiots. There's a rationale and reasoning for what we're doing, and part of it is just let me say that it's located very close to the University of California of Los Angeles. Otherwise, well, I won't tell you what it was otherwise known as when I was a kid. I think everybody's heard it before, but I'll let you imagine.
In other words, you deal with a lot of exchange students and a lot of exchange professors.
So anyway, and also we rented furnished to dissuade people from being there too long term, so we can not have to do cash for keys, so we can not have to do what I would call exorbitant relocation fees. So it works out pretty well, and we want some flexibility with this particular property. But anyway, so what was would you try and, I don't know, we'd like money as soon as possible, but I also don't want to put ourselves in a bad situation because it is a condo, and God forbid there's a flood, fire, crack at it, kick down the door, I don't know, something happened.
Anything can happen.
I want to just be able to be, oh, here's your holding deposit, sorry. So I mean, part of me is like, well, no, I can't give you a lease. I sure as heck can't give you a lease without, I don't know. So you would not even give like a blank lease without the address or anything?
Well, you can just remember, you just provided intent. It's something they can argue. Well, he was going to rent to me. He gave me a blank. He gave me a lease. He gave me a lease to look at. So the intent is there. So that's the only thing is once a blank lease goes out, whether you sign it or not, you're giving them the argument if you back out for any reason. If they intended it, that they bait and switch. I mean, it just goes down that real estate law of why did you back out? Now is it discriminatory? So it can create a whole nother problem for you.
So I guess I'm thinking that we did find like some international money transfer thing that is relatively low fee because that's how we sent the holding deposit, but it did take a couple days the first time. So I guess I'm kind of thinking like a few days before they're scheduled to take possession, give them the lease then and demand the money, and then don't even give them a signed lease until they take possession.
Right. That way your intent gap is a much shorter window.
Do you have, it's a stupid question because I don't know if you know the answer and it doesn't involve everybody else, but do you know if the CAA online forms, if you send it to be sent, is it possible to just like have it partially executed by a party and like print it out or something and have it fully executed by the other party? You know what I mean? Like
Yes, yes.
because
It runs almost like a DocuSign system.
right, but it's not DocuSign, so I'm not quite
Correct.
familiar with it.
I'm not entirely sure. I'd have to look at what CAA's verbiage is in regards to it, but it probably runs very similar to the verbiage in DocuSign. Yes, you
Well,
can
I suppose
contact
we
me
could
later
just
for attorney referrals. Sasha Struthers' information is here. I saw that Arlene put it in. Her phone number is 323-982-8825, and her website is www.struthers.legal.
Right, but I was looking for the
.com.
legal advice for attorneys. I know Tosh does the cash for keys, but I was looking
You're looking
for
for an attorney that does evictions? Call
correct.
AGLA or your apartment association and see who covers your area, and then you can make a decision from there. Okay?
Thank you.
No problem. I see Val has another question, and then I'm going to come back to you. Okay, Chris? Here's
Sure.
another issue that complex has a laundry room. The company who owns the machine is CoinMock. I have not received a dime from them in years. They say it's because they're not making any money. However, since it's been years, somehow my tenants figured out how to use the machines for free. I wouldn't care, except my electricity bill for that room is tripled to about $150 a month. My crew has gone there several times to see what's going on, but nothing unusual is plugged in. I can't imagine them doing that much laundry, but it is possible. My crew suggested I cancel the electricity and have the machines picked up. In the meantime, I'm looking into purchasing a pair of coin-operated machines. Would you scold me if I turn off the power? No. You want to know what I would do?
Yeah.
I would serve a 30-day notice of change of terms of tenancy, letting all the tenants that are currently there on a month-to-month know that we're no longer providing laundry coin-operated facilities, and they needed to find a local laundromat. And then on day 31, I would remove the machines, lock that room down, fill it full of stuff for storage so no tenant moves in there or plugs something in there thinking that they can hijack the electricity from there to run their freezer or whatever else they're going to try to do. And that's how I would handle that. And the reason I'm telling Val that is she's in Kern County. She can do this.
CoinMac is very smart. They make a long-term lease, and you cannot easily just get out of it.
Right. So watch yourself, Val. You may just want to let the machines sit there and bolt off the laundry room. That way they're still there. That way that company can't charge you. If they're still on the premises and you didn't make them take them away, then they're still there and you're not in violation of your contract. Wink, wink. Just lock the door. I'm a jerk sometimes, you guys. But I think that's a great one. Okay, Chris, did you have something else?
Wasn't really something else, just
Go ahead.
so the way to handle it then, it sounds like, is to tell them, no, you're not going to get a lease until a few days before. Like that's, if you're not willing to send money or whatever, then you're not going to have a place when you get here from Paris. You won't get a lease until a few days before, and the money has to be hard before I'm giving you the keys. Like, it has to be.
Unfortunately, because this is coming international, we can have special process and procedure for international occupants.
Do you have authority for that?
You sure do.
But do you know where the authority is for that?
On your criteria.
Okay.
Got it?
Yeah.
Okay. I hear something going squeak, 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 squeak. Sorry. Go ahead. I heard another question.
Can you do that with any of the laundry people? Like we have wash, and they're contract is complicated because we've been here for over 30 years and it was a contract that was inherited. And when we go to talk to them, they said they can't read their copy anymore from a long time ago. And they want you to renew and make a new contract. And I refuse to make a new contract all these years with them because they just want more money, but they're not letting me out of my contract. So I can do the same thing that you just suggested, give everybody notice saying that we're no longer doing that and just lock the door.
What city are you in?
Downey, this is Lisa again.
I got you, but you see how important that key factor is in what we talk about? So give me a minute.
Okay.
You're in Downey. You're not governed by DCBA because you're in an incorporated city. You're not on the list. You're only governed by the TPA.
Yes.
So every time you talk to me about your doors, okay,
Yeah.
you're going to have to say you're going to have to say incorporated city of
Okay.
Downey governed by the TPA.
Okay.
Because if you say that to me every time, I'm going to know. But what I'm going to ask you is multifamily or single family. That's the only other question. So you could say multifamily in Downey governed by the TPA. And then I'll
Yes.
be able to answer your questions much faster. Okay?
Okay.
Because other than that, every time I'm going to go through that Rolodex. Sorry. It's just the way my brain works. I'm sorry. Okay, ask me the question again.
It is multifamily. I wanted to know, we have the wash company for the laundry facility.
You said something in the wash contract that got my attention from a legal perspective. And you're holding Willy Wonka's golden ticket and you don't know it.
Okay.
You want to know what it is?
What is that?
They can't read their copy of the contract.
Okay.
They can't read their copy of the contract. How can they hold you accountable to something that is illegible?
Well, that's true. Yes.
Okay. Do you see something coming through the chat right now? I can't say it.
No, what happened?
Somebody unmute yourself and say that out loud. I can't.
Bingo.
Thank you.
Okay.
I can't give you legal advice. But if the legal document is ineligible, they can't read it, then what is it? Toilet paper?
Okay.
I'm just saying. Okay.
Okay. Thank you.
So tell them if it's then come pick up your machine because you don't have a contract with me.
Okay.
Oh, we have a contract, but we can't read it. Oh, I'm sorry. It's not with the owner of record. Good luck.
Okay.
Come get your shit. That's what I tell them. Good luck. But they're telling you that they can't read their own contract. They're giving you the ammunition to let you know that they don't have a foot to stand on when they get into court.
Okay.
Hold on. We're getting something else. There is something called the statute of frauds that may or may not apply. You're getting another golden ticket.
Okay.
Write that down. The statute of frauds.
Okay.
Okay. Tell them to come get their machines or you're going to be contacting your legal counsel regarding the statute of frauds.
Okay.
And if they think they're going to take money that they've made collected off of that property, off your premises, they're going to have to speak to your legal counsel.
Well, we've never made money from them either.
Have you collected the money?
I have not collected it because
they're making money off of you, off of a contract that's not valid?
Yes.
Are you hearing me yet?
Yes.
Okay.
I've told them that we don't make money from it before. And they say,
no. You don't know what's made because they come and open those machines. You don't touch them.
Right.
So they're making money off of you, off of your electricity, off of your water.
Yes. That's why
now you're hearing what I'm saying. They're illegally making money off of you, off of a contract that they can't read.
Right.
It has to do with contract law.
Right. Okay.
Okay. You're holding a golden ticket.
Okay. I'm going to use it. Thank you so much.
No worries. Thank you to Chris for giving us the other
Thank
verbiage
you.
that we needed. All right. Anybody else have anything?
Have a blessed day.
What do you mean by statute of frauds? Can you explain that?
Okay. Let me explain something to you very briefly, okay? Chris, be nice. Look at it this way, okay? Think of the statute of limitations, okay? Just think about that for a minute, okay? So there's a whole statute out there, meaning a law, process of law, okay, that says the only time you can sue somebody for a landlord tenant issue is 2 years if it's an oral contract or 4 years if it's a written contract. That's a statute of limitations. So there's a whole thing of statute of limitations, and that recently got changed with people that were sexually abused or sexually assaulted. Remember, they could go back for their whole lifetime if they were assaulted or something like. So different statute of limitations. So there's a whole legal process to tell us what our legal limit is to go back and sue somebody. There's a whole statute out there that talks about frauds. Okay? And the reason he's saying to bring that up is because remember we talked about the statute of limitations earlier? There's this statute of frauds that kind of goes the same way, that says you can't have a contract you can't read that's ineligible, so you don't know who it's with, but you're making money off of that person every day. That's fraud. That's illegal. It's probably in the statute of frauds. So he's pointing you which direction to go hunting, is all. I hope that makes sense and you now understand. And
Yes.
he's seriously telling you to Google it. But just look at it in that perspective, okay? There's a whole statute there to help protect for frauds, limitations. He's like, neither are you. You're not right. Go look it up. I love you guys. Okay. I'm not giving you legal advice and neither are you. Go look it up. That's what he says. Okay. But he's just trying to tell you, go that direction. That's all. Anybody else have anything? Nothing? Did we scare everybody? All right, you guys, it is 1:34. Thank you for spending your lunch hour with me. We will be back next Wednesday. We're on time for next Wednesday, so that should be good. Doesn't look like we have anything crazy going on.
See you tomorrow
Where are you going to see me tomorrow?
with the apartment association in Long Beach.
That's at 7:30 at night, right?
Yes.
Yes. So yes, I'm doing a live webinar in the evening, I believe at 7.
I think it's 6:30.
I think it is. I think you're right. But my brain is going not during the business hour, after the business hour. Oh, my brain works in weird ways. But yes, I will be on there. And we're going to be talking about current events. So keep feeding them to me tomorrow too. We want to talk about bed bugs and make sure that everybody's aware of that with all the bouncing furniture that we have right now with the fire victims and them trying to get fire victims placed with furniture. I want to be careful that we're not inviting bed bugs into our properties. So definitely something that I'm going to be talking to, because that's a word I definitely want to get out. So I will be talking about that tomorrow night. And if you guys are able to join us, please feel free to do so. We'd love to see you there. Anybody else? All right, everybody. All right, everybody. Have a great day.
Thank you too. Bye-bye.
Bye.